All right. Well, thank you everybody for joining us. My name's Courtney Self. I'm the broker here at Harcourt's Hunter Mason Realty. The host, Tony, is my husband and partner. And he's been telling me for years to use Zoom and to get used to it. And I resisted, and now I'm having to do it regardless, whether I want to or not. So we have a great speaker for you today. His name's Joe Donnini. He's an attorney. He's been in the business for almost 25 years. I've known Joe for probably 10 of those years. He's a member of the CAR Legal Hotline panel. He's extremely well versed in real estate issues. He's worked with RE/MAX on their corporate team. Also, he's worked with Harcourt's, I believe, on their team as well. So, and I know he works as a judge from time to time also. So he's the expert. He's the one you want to talk to because we have a lot of questions surrounding not only the new rent control laws, which seems like that happened so long ago and that's old news, but now with coronavirus and the tenants hearing that they don't have to pay rent, that's going to be a big challenge for landlords and for agents who work with landlords. So I'm going to turn it over to Joe. Thank you for doing this for us. We really appreciate it.
Well, thank you for having me. I'm happy to be able to hopefully share some information and take some questions too. And I guess just to give us a little bit of a framework based on the topic with the issues going on with COVID and landlords and tenants, the theme I thought that might be most helpful today will be orders and options. So we'll talk about the emergency orders, what some of those mean, some of the questions that have come about that are more so than the answers, and then maybe some practical options and some considerations for us to think about going forward in the very short term. So, and after that, as Tony has alluded to, anybody that has any particular questions, he'll coordinate all of that and I'd be happy to respond. So as we all know, we're in some unprecedented territory here with a lot of different issues, including the landscape. And as most of us are aware, from the state level going down to local levels, there have been moratoriums on evictions for both commercial and residential. Coming from the state level, the emergency order that included, amongst other things, the landlord-tenant issue was a moratorium on the evictions and the tenants, residential tenants, not having to pay a rent and having to indicate or communicate to the landlord and giving us within 7 days of when the rent was due, which presumptively would be April 1st, within 7 days, and to have documentation supporting that the reasoning was due to the COVID virus. They do not have to give the landlord that documentation, but presumptively the reason for it is that if there ever was an eviction or an issue, that they have some evidence to support that they were in compliance with the order by lawfully not paying rent due to COVID. We've seen at the local level, particularly more so at the LA City level, they've been a little bit more getting more press, more attention, where at the LA City level, City Council just recently enacted a 12-month ability to repay any rent that's not paid while this order is in effect until May 31st, as far as the moratorium goes. And what's a little bit ambiguous, or actually let me take that back, a lot ambiguous about that 12-month ability to repay rent that wasn't paid while the order is in effect, is does that mean that it could mean several things. One thing it could mean is, does that mean that the tenants, if they don't pay, they have 12 months upon which to pay it, and when the order is lifted, let's say it is lifted by May 31st, if it's lifted and they fail to pay on June 1st, does that then allow for a landlord to still go forward with an eviction based on non-payment for that going forward period, and just allowing 12 months for the tenant to pay the go backward period that they failed to pay the rent? Or, which would be a worst case scenario, does that mean that during that 12 months, the rent can't be collected and it de facto ends up giving tenants a longer moratorium than the May 31st deadline that's on there? I would think, and this is probably just an opinion of myself, that if that latter ended up being interpreted that way, we would hopefully see some advocacy from some of the real estate groups and or local politicians, state politicians, to give more clarity and more balance to that interpretation, a balance for landlords and tenants. So there's also cities that have also enacted these. And under the governor's moratorium, under his emergency order, if there are cities that have more restrictive means by which they're operating, they are allowed to do that. LA is one example. It wasn't a statewide order with the 12-month. And by the way, for commercial, they've given 3 months that businesses are allowed to pay the rent back if they, from once the order is lifted. So we have this scenario where not only are we seeing emergency orders come out, and they're not very well defined. I mean, there's an argument that they've been made very quickly without thought for possible unintended consequences as time goes on. But we also have another layer with the court system, that not only is there this moratorium that most of you are probably aware of from just the news cycle giving us that information, but in addition to that, we have not just the May 31st deadline, but the courts have had other entities, they have had a plethora of orders that have come out. Just to give you a quick example, originally the courts were going to be closed for 3 days on the 17th, 18th, and 19th of March. Presiding judge came back out and said that pursuant to authority he got from the Chief Justice, courts are closed until April the 16th. That could be extended, but their Chief Justice has put slowing down a lot of civil and even some criminal stuff through June 22nd. So there's still a lot of ambiguity in the court system itself. We're actually looking at doing things remote. Historically, we were able to do things that we would call more benign or easier types of housekeeping or other more simple types of appearances through telephone and video, but now they're looking at expanding that to allow courts to get to function. So I share with you, first off, all of these orders and these realities of the back and forth and kind of the confusion of what's going on, because since we definitive, thou shalt follow the rule and here's what it says, guidance or clarity, it allows for us to kind of get to the other part of what I mentioned, options of how can we react or how can we protect ourselves and try to balance the landlord-tenant equation, given that everybody is arguably impacted in various ways by what unfortunately is happening in our world today with this pandemic. So number one would be, and again, it seems pretty basic, but it's almost like the guidelines we hear, they're worth repeating about washing your hands and staying so many feet apart from another individual, et cetera. So number one would be communication. If if you're a landlord and your tenant hasn't reached out to you, there's nothing that prevents you from reaching out to them to take their temperature, so to speak, not literally in terms of any COVID issues, but to get a feeling or seeing how they're doing. Because, at this point in March, the impact of the economy hasn't necessarily hit everyone yet. There's some people who have been drastically affected, some at various degrees. So there can be tenants who at least from April 1, are good. So communicating with them, if they haven't proactively communicated with you, is important, because it ties into number two, which is that if you're communicating, you might be able to work something out, because there are some tenants out there who have misread, just like some landlords who have misread some of the orders and some of the guidance that's been coming from state and local officials. This does not mean it's a free rent time. They still have to pay rent. The law actually provides that if you as a landlord need to evict a tenant for a reason other than non-payment of rent, you still can do that. Arguably, it's a little bit misleading because the courts are not open to allow that to happen. So it ends up being where evictions in general are on pause. But back to that list of one, communicating, two, negotiating. If you are negotiating and you have tenants who are trying to do the best they can, given challenges that they're facing, my suggestion would be that whatever cash you can get is obviously important, because I'm sure if you've been a landlord for a while, you do know that in situations where it's unfortunate if a tenant fails to pay and you do end up in an eviction scenario, typically you're trying to get possession back so you can get a paying tenant in there, and it becomes increasingly less likely as time goes on, that you'd be able to recoup the rent, even if you get a judgment for that back rent. So if you can get some sort of money up front, and the word that I'm using is deferment, not reduction, but deferment of the rent into maybe a 2-month cycle. So translate that into an example. Jane Doe owes $2,000 April 1st. And Jane, through communication, it appears that Jane can pay, only $1,000. You might want to have an amendment draft. Jane would pay you the $1,000, and it would be part of the base rent. And if you're using CAR agreements, rent is defined in the CAR agreements, and you want to tie that together and make sure it's included, that you're deeming it to be the regular base rent. And then you may defer, not abate, not reduce, but defer maybe $500 to be paid in addition to the $2,000 due on May 1st and another $500 due on June 1st. Now, reaction might be, well, gosh, that's only 30 days away. They may not be able to afford that. Well, again, we have so many unknowns going on right now, and we have so many changes in orders coming out that it's probably prudent to look at the scenario through a lens of 4 to 8 weeks and reevaluate. So in the next 4 to 8 weeks, if it works out that there is this financial assistance and tenants are getting, and there is cash stimulated into the economy in the next 30 days, assuming that actually does happen, then it's arguable that maybe that rent can be paid with the extra. And if in 30 days that is not the scenario, that things are either the same or financially they are worse, you can always reevaluate and look at whatever cash you might be able to get, if any, and add it on to some months as a deferment. That's probably a practical consideration. I know in our practice, we have done that for some clients. And again, it's a case-by-case scenario. It has worked out through effectively communicating, negotiating, and then documenting would be number 3. And the key for documenting is not just so both parties are on the same page. That's important. But the other key for documenting is really that in the unlikely or unfortunate, I should say, event that you end up having to file an unlawful detainer, you have the documentation that supports that it was part of the base rent. So when you go to do a 3-day notice, you can include that money as part of the rent that was unpaid for the period upon which you're giving a 3-day. Important to have that information in there, because once the courts do open back up, and if evictions do become necessary for landlords, that documentation can serve to be evidence in part of that case for you. So in summary there, really some of the options are the communications and negotiating to get some sort of cash, recognizing it may not always be possible. And in that scenario, if it's not possible, knowing that you can't evict, and knowing that there's not much that the law would afford you to do, at least until this moratorium is lifted, again, is really just going back to the table and seeing if there's anything that's possible for you to try to negotiate to get, because, food and some of the staples are obviously over their head. And I think through effective communication, the tenants who are going to try to do the right thing with the stress that they have in their lives going on, stress that landlords have when their lives going on, I think there could be at least some sort of cash that might resolve. Because let's face it, if they're unemployed, supposedly they're going to be getting not only the unemployment, but a $600 per week add-on from the federal government. They may be getting from certain larger employers have the ability to have them on payroll a little bit longer, and we're keeping them on. So again, it's not that tenants across the board have now necessarily lost 100% of their income. That could be the case for some. All I'm trying to do is say that there are case-by-case scenarios. So by following the communication and seeing if hopefully the tenants that you have can work with you on number 2, negotiating, so that number 3, you can document, at least it's kind of a better alternative in a situation that's not an ideal situation for anyone involved. And as these orders evolve and change, it's very possible that in the next 4 to 8 weeks, and again, I don't have a crystal ball, so I'm not, advocating that things are necessarily going to get better, and I'm certainly not advocating that they're going to get worse, and I'm not advocating that they're going to get the same. I don't know. Personally, I'm very optimistic that things will get better, in the near future. But whatever that date is, I don't think anybody really has their hand on it. So that's why I think taking a step back and taking a deep breath through all the stresses on landlords, tenants, and really just looking at the next 4 to 8 weeks and deal with that breaks it down into those boxes, if you will, of time increments to address what's in front of us now, revisit it when the laws may change, circumstances and life may change. And if it's better or worse, at least we can then deal with it in what we might call box number 2, which is a further time increment going forward. So I think with that stated, we're close to about the time to open it up for any questions that anybody has that I'd be happy to take. Oh, you know what, Tony? Actually, before we do questions, I do want to add one little thing. I wasn't sure if we were necessarily sticking with just residential. So if you don't mind, I'm going to share a few thoughts on commercial. Because I've been getting, we work with a lot of landlord tenants. We also work with a lot of businesses. And I cannot tell you how many calls, I can't even keep track of them, of this question is, and actually attorneys have been calling me on behalf of their clients as well to say, what are you doing? Because we have clients who not just have necessarily lost their business, like for example, a restaurant, a nail salon, a hair salon, those types of retail type businesses, mall-based businesses, they have been under these orders, been ordered, they're non-essential businesses. They literally have gone from, one pendulum swing all the way over to the other pendulum swing with absolutely no revenues, but the expenses didn't disappear other than maybe some labor costs due to layoffs. So then there's some other businesses that by virtue of the buildings being locked down or shut down based upon various reasons, landlords haven't been able to access premises to even do work, and maybe some of these businesses don't necessarily can function on a remote level as some other businesses can. So the question has come up a lot that tenant attorneys are posing to landlords or landlord attorneys is, well, hey, if I can't fulfill the terms of the lease, the purpose, because in all leases, there's typical clause called, what's the purpose of this lease? And it's to provide, a restaurant or any of those businesses aforementioned name. But now due to COVID and government orders, I can't perform. So am I excused from my obligation to pay rent? I believe I am as a tenant. I don't want to pay rent because I can't, because I open my business. Therefore, my lease is frustrated and I should be excused from that obligation. So you'll see, and in fact, I've actually seen from some lawyers who are using the following arguments. I'll throw out the fancy legal words and I'll try to explain what they mean is we have some doctrines called impracticability, doctrine of frustration of purpose. These are case law doctrines that have been on the books for quite some time. And they're resurfacing now because commercial tenants are trying to use these doctrines to excuse performance for payment of rent due to COVID. Also, juror clauses are coming up. There's talk of them being employed. What do all those mean? Basically, there are legal reasons upon which performance can be excused to pay rent. Typically, force majeure, which many of you may have seen in the leases or at least heard about, clauses where acts of God, war, terrorism after 9/11 started creeping in as part of the definitions of those clauses, that if any of those events occurred, then people would be excused, parties would be excused from their performance obligations. But pandemics like we're experiencing now, obviously, no one's ever really thought of this kind of scenario where we're arguably shutting down a world economy within a matter of days. We've done this, and whether or not that would fit within the definitions of a force majeure or impracticability. And there's elements like anything we deal with in law. There's certain things that have to meet a definition. The doctrine of frustration of purpose, that there has been something that's occurred that has frustrated the purpose of the lease. From a practical effect, tenants will inescapably and adamantly argue that the frustration has occurred based upon the fact that they can't do the business services or products that they otherwise had engaged to the lease or contracted in the lease to perform or to sell. Whether or not these will work are going to not be dealt with today, because if an eviction ever was to occur on a commercial basis, these are things that the courts would decide. So if in a UD court, an unlawful detainer court, a commercial landlord, ultimately when the moratoriums are lifted, sues a commercial lessee, and a commercial lessee brings up the defense to say, I shouldn't be responsible for the rent for those months, and or possibly going forward. That was another question we've had recently at office. I should be excused because of these legal doctrines, and the lawyers are arguing the circumstances and the specific facts of a particular business and why that they should qualify under this doctrine. It's going to be a trier of fact, and in UD cases, typically those are done with just what we call bench trials by the judicial officer, the judge. They are typically not done, although they can be done if they're requested by a jury, and it would be up to those triers of fact to ultimately decide whether those legal defenses actually apply to excuse rent performance. So circling back to like I did on residential, if any of you are involved as commercial landlords or tenants, I still think, given where we are with all this uncertainty, this three-step process that I outlined earlier about communication, negotiation, and documentation still holds in the commercial context. That if you can reach out to your tenant, if your tenant hasn't already reached out to you, and I have seen on both sides of the table, particularly on the residential and on the commercial, where dialogue has been happening and people are sort of trying to get in this together and trying to figure something out. Of course, there's going to be examples where the breakdown is there and it is what it is and you just have to accept that and deal with it. But I think that communication that can then be memorialized in the documentation and then reevaluated in maybe another 4 to 8 weeks, and you can kind of go from there. So I just wanted to share a little bit there about the commercial in case that was relevant to you. Since we're still sort of within our time allotment, I wanted to be respectful of everyone's time. And now I'll go turn this over to Tony to see what questions we have.
Right. Thank you, Joe. That's very helpful. We have our first question. The question is the landlord required to send a notice to all tenants notifying them of their rights regarding not paying the rent?
As a general answer to that question, I am not aware of any statewide, or like I said, LA City gets a lot of press, more so than the local jurisdictions. I'm not aware of any notice that a landlord is required to give, at least in CAR is rapidly evolving. The only thing that and this isn't relevant to our conversation, but there's been a COVID amendment in the sale of residential property that CAR has drafted just recently. So the short answer to that question would be, it's my understanding there is not anything that's incumbent on or a burden on, not a burden, but a requirement on the landlord to notify the tenant. Tony, you're muted.
Sorry, there we go. Hey, thanks. If anyone wants to ask a question, it is now your time to do so. Just raise your hand and I will unmute you, and then you can unmute yourself. And while we're waiting for people to find their questions here, we might have a shy group. So my question, so another thing too that I've been hearing about, Joe, is that you have to have proof that you have a hardship. I've been seeing kind of mixed items on that, and I've had a number of calls from my tenants, and essentially it's one of those whole things is that, you know, you just take it, because we know everyone's affected pretty much. It's going to be a matter of when or if. Do you stay hard and say, look, I want to have written proof that you're having a hardship as a tenant?
That's a really good question. My recommendation would be the law is ambiguous. It just says it's part of the statewide order from the governor. And it just says that the tenant is required to keep documentation, not give it to the landlord, but required to keep it. There have been some interpretations of what that documentation might be. So there's nothing that prevents a landlord from saying to a tenant when they say, hey, you know, landlord, I can't pay you April 1st rent. And landlord says, I understand, but do you have any documentation, you know, showing that you've either been laid off, you're caring for someone with COVID, you yourself have COVID, or there's some other reason related to COVID as to why you economically or health-wise cannot pay the rent. But the challenge is going to be, even if you ask that as a landlord, there is no requirement a tenant has to necessarily give it to you. Right now, all it says is they're required to tell you within 7 days. So there's a requirement on the tenant to within 7 days notify you. But interestingly enough, I'm not aware of any consequence by the tenant if they don't notify you in 7 days. It just says thou shall notify. Well, if they don't, does that mean that, if they didn't timely notify, then they must pay the rent? I don't think that's the interpretation, but point there is simply to say there's no consequence if they don't notify you, and there's no consequence if you ask for documentation or support that validates the reason why they're not paying the rent, because at this point, depending on how you look at this, good or bad, it's basically almost anything could be argued that's related to COVID as to why they're not paying the rent. So for you as a landlord to ask it, no harm, but level your expectations down to know that if a tenant doesn't give you anything or just verbally tells you an answer, there's not much in terms of consequences you could do thereafter, because the law doesn't say so, that there is a consequence, and there's these moratoriums going on.
A follow-up to this question is the question, does a proof of hardship, is it required for all rentals, single family, condos, apartments? What if they don't provide proof? Can you evict?
Well, again, the proof of hardship is required, but there's no consequence stated, at least as of now, unless they come out with a further order when the dust settles a little bit in terms of when the moratorium is lifted. So there's no consequence to the failure to adhere to the requirement of documentation. What I can tell you that I would suspect could happen is that if they don't provide you proof and you try to evict later, let's say the moratorium in a hypothetical is in fact lifted on May 31st. Let's say you're not in LA City, you're in a jurisdiction that hasn't enacted any kind of time allotment to repay the rent for April and May. Let's say you're able to file the courts, let's say they're back in business by June 1 on evictions. All these are presumptions, right? So if June 1, you're able to file an unlawful detainer against someone for non-payment of rent, if they do show either they were a letter from a doctor, a layoff notice from an employer, if they went and collected unemployment, you're arguably going to be in an unenviable situation as a landlord, because the likelihood is they have met the very loose requirement of, at that point, providing something that they didn't provide to you when you asked it because there was no requirement they had to. But if they do it in court and a judge sees that they've had what the law says that they had and it looks sufficient, there's probably a high likelihood that your eviction would not go forward, that they would be excused, at least on the non-payment of rent issue. If you're suing at that point for possession, that's going to be a different issue depending on whether it's after the moratorium is lifted and then any non-payment is not deemed to be due to COVID. At that point, you may be able to evict on a go forward. But again, we're just talking about this window of till May 31st. It's going to be a challenge, unfortunately, unless they clarify and give more info in the next several weeks.
So another question is, there's two school of thoughts. One is if you go to your tenant proactively and ask them, and others where you just hope and pray that they do pay what they can or pay what they, because a lot of people are not affected. Some have jobs and that and whatnot. So the question is it, do you just wait, or do you advise you be proactive and ask your tenants if they're okay?
Well, again, that's a judgment call, not a legal call. So if you, typically get your rent by the 2nd or 3rd of the month from your tenant, and then all of a sudden April 1st, it's now April 5th and you haven't gotten it, just me speaking, I probably would proactively reach out, not so much to be like, hey, your rent was due, where is it? But to be like, hey, your rent was due, I didn't get it. And the reason I'm calling is I hope you're okay. I know we're all, experiencing challenges together. And I was just wondering, hopefully you were able to have mailed me that check. And I just wanted to confirm that I wanted to make sure that you're okay and that you're able to pay the rent, and just keep me posted as the weeks go on and let's stay in touch kind of message. So I'm not saying that's necessarily the answer you have to do, but I think communicating and letting them know that you're not just the landlord collecting money, but that hopefully you truly do care, that might invite you to, on their mind, reciprocate and treat you as hopefully a priority like food and shelter, and not just the big bad landlord perception collecting rent.
Okay, another question here kind of on the same thread. If I don't receive the rent within 7 days, should I then communicate with the tenant to see if they can make a partial payment? If they cannot, then what should I do to document this going forward?
Absolutely. On the first part of the question, if you don't receive it by the 7-day period, that ties to my number one about communication. So you should reach out to them, whether it's through an email or verbally, so that you can see if it's possibly in the mail. Maybe they were waiting to get some unemployment or some money in, and maybe they mailed it on the 6th and you just didn't get it yet. And excuse me, in our experience too, the U.S. postal system in recent years on local mail hasn't been as quick as it used to be. I'm not sure if that's something you all experience too, but things that used to take maybe 1 day or 2, sometimes are 3 or 4. But the second part of the question is that if they pay only, I'm reading the thing here. Let's say they owe $5,000. Do they have to repay 10% per month from the amount? Is there a timeline for repay? There is a moratorium on late fees and everything else. You can't add, if they don't pay the full amount during this order period, at least until May 31st, you cannot enforce any other provisions of the lease that affect late fees or any kinds of add-ons. If they make a partial payment, let's say the rent was $5,000 and they paid $3,000, I would probably, if it were me, call them up and sincerely thank them for paying the $3,000, given what's going on, that you really appreciate that. But you also, are in a bind yourself, because this affects all of us, that the $2,000 that's remaining, that you're willing to work something out with them. And I throw the question back to them is, when do you think that you might be able to, even if you had to make 1 or 2 or 3 payments, I'd be willing to work with you, but when do you think you'd be able to get that extra $2,000 of the rent to me? And if they say, I don't know, my thought is, well, do you mind if we revisit this in a week to see how your financial situation is, to see if maybe we can come up with a solution in a week? If they say, well, I think I could pay you $500 in 2 weeks, and maybe I could pay you, but then I'm worried about May 1st coming around, I would say, well, then let's get an amendment done that, I would probably take whatever they're giving. Like if they could pay $500 in 2 weeks, that means now instead of $2,000, I'm $1,500. Because with the tenancies, unlike banks and mortgages, if you don't pay your mortgage, even though they have some of these qualifying for 90-day deferments and they'll add your mortgage payments onto the back of your loan, the bank has your house. They have your security. As a landlord, if a tenant fails to pay, ultimately, yes, good tenants will try to work something out with you. They're not, this is an unprecedented situation, but typically getting back rent is not as common as it is for a bank to get the money owed because of the collateral they have secured. A lot of landlords end up just getting possession back. And in my experience, I'd say just anecdotally, probably 50% or more don't get back rent. They just get possession. So I would say, to answer that question is, get that, like in that example, get that extra $500 in 2 weeks, cash is king, and keep communications open, because the more that you keep positive dialogue, the more likely it is if money comes in, you're going to be on the priority list, rather than, if it becomes more of a bill collector, debt collector, you'll probably move down the chain, because a lot of them know they don't necessarily, you don't have much you can do with the moratorium being in effect. And as for a timeline, the last part of that question, I would simply say that you should, again, keep it on a short time frame, because it gets back to my earlier comments about revisiting things in 4 to 8 weeks. I would not give them, if someone says, well, unless you're in a city that requires it, like Los Angeles City. But if you're not in a city that has anything like that, I would simply say, if someone said, well, I can pay you the extra $1,000, but I need 6 months. I said, I'll tell you what, why don't we do this? Pay me $500 and $500. We'll do it in 2 months. And if you can't make the $500, we'll talk again at the end of the month. If you can't add that $500, and we'll go from there. But for now, let's just keep the documentation and the past due amount in a 2-month time frame. Because if circumstances change and things are better in 2 months, and somehow stimulus money is coming in, or somehow if we're looking at this and the positive stuff occurs, you want to get your money in too in a short window rather than financing that for a year.
All right, we have another question here. Tenant has been behind on payments for the last 6 months, was making partial payments only, and always there was a balance due. Since she moved in back in July, will COVID-19 help her waive her due payments in any way in the future? She's saying she's been asked to self-quarantine. She's paid by UPS.
So if I understood the question is, the tenant has been past due for 6 months for quite some time prior to all the COVID issues arising.
Right, yes.
Okay. Then that's a double-edged issue there, because it does not negate, there's an argument to be made that money is something that could be sought once, again, the moratorium is lifted. So you have several layers there. In other words, assuming May 31st comes and the moratorium is lifted, and if you end up having to file a UD, there's an argument that, you'd be able to get the rent from prior to the March-ish date of COVID officially coming down with the emergency order, whatever the governor's date there's been so many orders out, it was probably the third week of March. Anything prior to that order, when the moratorium is lifted, and again, my example of, let's say it's in June, that the UDs are back in action, you would be able to get the rent as an order, hopefully as a judgment. Whether you can collect on that's going to be a whole nother issue. But from the COVID period going forward, that could most likely, based on the facts you just gave me, be excused due to COVID.
So just a comment from the previous one that there's, at the end of the day, there's no rules for repay, just all up for negotiation.
Unfortunately, that seems to be a reasonable interpretation. That's why, negotiations was one of my listed items of communicate, negotiate, and document, because the law is extremely, they're unilateral orders coming out from the executive branches of government. They're not legislated because they've been emergency. Under the police power of the state, they've been emergency orders. The reason I simply share that is to say that they're so broad. They're raising much more questions than answers, as you can see from today's conversation. So that's why I think if you've heard anything of what I'm saying today, I've been more coming at it from a practical perspective of really partnering with the tenant in negotiating, even though you have a lease and you have a lease that says they owe you this contractual obligation, given these unprecedented circumstances and how broad these orders are and how they could possibly get even more restrictive. If other cities pick up on LA City's 12-month allowance to pay back, and assuming there's no organizations that fight that or challenge that as unconstitutional or an usurpation of the police power too far, what have you, that's stuff that's not going to go quick. That's stuff that's months in court systems down the road. That's why I'm saying is, who wants to wait for a court system to play out? People want cash. They want money. So that's why I'm saying, treat this more like a partnership with your tenant, even though technically it's a contract and they owe it to you legally, because I think that's where you're probably going to get more practical effect by treating it as a partnership as opposed to the landlord collecting rent that you might have done in January and February of this year. But for the next couple of months, you might want to consider changing your mindset.
I'm sending thank you notes to everybody who pays a rent, just to let you know.
Honestly, Tony, that's a great suggestion. Because again, I'm not advocating for you to be fake or being manipulative of like, oh, I'm trying to act like I'm caring just because I want the money. While there may be some truth that you do want your money, I think that's that's a given. It's kind of analogous to networking. When you're at a networking group, if a lot of you on this video are agents, walking up to somebody at a networking group and saying, I want to sell your house. Are you selling it? Do you want me to list it? Let's meet. I want to do a presentation. That may be a turnoff as to building the relationship and getting to know somebody and ultimately developing a client relationship in any of us that are in the service business. It's the same thing with the tenant in this kind of situation is, if you can get to know your tenant a little bit, and hopefully we all really do care because we all are in this together, that can go a long way in the business relationship. And as Tony said, I think that's a great suggestion of actually, I may do that. I may take that suggestion and send thank you notes to those that are able to pay.
So we got two questions here for you. First one is a commercial question. A commercial tenant that showed bank statements 2 months ago had plenty of money, has emailed the landlord that they are not paying April rent. The order is, if you can pay, you should. Is there anything that can be done to push for payment now?
Unfortunately, it gets back to what I was saying earlier on the residential. There is no teeth in any of these orders. So if you have reason to believe, based on, for whatever reason, they showed you those bank statements, if it's a new tenancy, or whatever the reason is, that you have seen the company's bank statements indicating there is significant or sufficient funds upon which to pay the rental obligation, and now the tenant might possibly be using COVID as a reason to either not pay or conserve cash to pay, make that cash last longer. If they don't pay you April 1st rent, there is a moratorium on the evictions for commercial as well. No commercial tenant can be evicted while the moratorium is in effect. And in LA City, they have a 3-month period upon which to pay back any rent not paid during the period. And if other cities start adding that stuff on, the short answer is there isn't anything. So again, not to sound too repetitive, I would treat them as now a quasi business partner, and maybe delicately share with them that, I'm just trying to understand, based on the information you provided to me, it appears there were sufficient funds. I can appreciate you might be trying to conserve those funds, but just as you are, I too am trying to conserve my funds so that I can make my mortgage payments. So anything that we can work together that you can hopefully pay as much, hopefully all the rent, would be beyond appreciated. So what do you think you could do for April? And then you throw the question back in their lap. And again, that might sound out of the ordinary, but again, given these times and given how these laws don't give you consequence or teeth right now, at least in the next 4 to 8 week window, I would suggest trying to do that.
So this is a good question, because these communications probably should be documented. So this question is: would you consider text and email a valid documentation, or do I need actual addendums or contracts signed?
Well, as you mentioned, from one of the lenses of the law that I look at when I see stuff in court, there is a deference to any kind of documentation sufficing, whether it's a text, an email. Certain bench officers, certain judges will allow cell phones evidence to come in if there were text communications. However, the best, if I'm giving you the best source or the best recommended best practice, I would say that if it's simply just communications, I would advocate for, at least at a minimum, doing it via emails. I mean, text is arguably the same thing, but I find in text people tend to be a little less descriptive because you're using a smaller device. Whereas on an email, if you're using a keyboard on a laptop or what have you, you can tend to be a little bit more detailed, and you want to be as detailed as possible factually. It's not detailed on law, just detailed on the facts of whatever communications you have. But if there is an agreement, meaning a deferment of rent, or in some cases, if a landlord is in a position to do an actual abatement or reduction, it should be clearly documented in an amendment to the lease. Because again, that's going to be stronger evidence if you do have to end up in court.
Okay, so I'm seeing no other questions. No one likes to talk. Everyone was bashful on this one. This is the most thing I've read here. All right. So, Joe, I don't see anything else here. Why don't you go ahead and give us your closing, and we'll go ahead and conclude the webinar.
Well, thank you, Tony, and thank you, Courtney, and thank you, everybody who's on here, all the participants. I'll just sum it up by saying this is, unfortunately, when people talk to a lawyer, they want to know, well, what should I do? And what does the law say that I'm required to do or have done to me? But in this case, as you probably heard through today's webinar, it's just not normal. It's just not typical. So the best that we can do is watch for short windows of time to see if we get further clarity in the law. In the meantime, try the practical routes of communicate, negotiate, and document. And at that point, if for those of you that do have any specific needs or questions, or you need documentation drafted, we do work with clients on doing all that sort of stuff. But for general purposes, or things that you could arguably start processing on your own to not have to necessarily engage professionals but work on your own would be at least preliminarily to follow the communication and negotiation. And if it gets to a point where you need documentation, you can always seek a legal professional if you feel that you want to have your ducks in a row in case you had to evict once this moratorium is lifted. In the meantime, obviously, let's hope for the best. Let's hope that everyone is safe, and also that things will start coming back to as much of a normalcy sooner rather than later, whatever that date is. So thank you all.
Thank you, Joe. And also went ahead and you want to thank Joe for taking his time. I mean, he's been on the phone nonstop, as you can imagine. Here's his contact information. Both Courtney and I have used Joe. He has a special expertise when it comes to real estate, and you'll find that not all attorneys are the same. They have a specialty, and Joe absolutely knows this space quite well. So if you have any questions, I encourage you to give him a call. We did have one question as well about future webinars. I'm sure Joe will be open to.
Sure.
We'll go ahead and send this out to the group. We did record this, so we'll have it available too if somebody else missed it or you'd like to pass it on to someone that understands.
Yeah, I'm happy, Tony, and you're welcome, Terry. I saw on the message board. I saw as the law evolves and when it's ripe or timely for updates, if we have something to say that we got more clarity or we practically have seen some issues arise, I'm happy to do an update and inform.
All right, so this concludes the webinar. Thank you so much for joining us today. We'll go ahead and again, it's a fluid situation. That's a word I've been hearing quite a bit. As this goes, we'll go ahead and update this, and we'll have Joe back on as our speaker. So thank you so much for joining us today. Have a great day, and be positive. Again, we're working this all together, and reach out to your tenants and thank them for helping you. Because again, everyone has said that anything with lord in is never a good thing. I always say property owner because you have drug lord and other kind of lord. So I like to use property owner. We provide housing for a lot of people.
Or property partner.
There you go, property partner. So that's the whole thing. So thank you so much for joining us, and you have a great day.